Hello again, dear students. I am Ömer Ali Girgin and I am a research assistant in Anadolu University Faculty of Law. I am here to explain you the Introduction to Law book, Chapter 7, Law of Civil Procedure, Compulsory Enforcement, and Bankruptcy. Here we go. You will be able to explain the following topics after this chapter: litigation, courts, judge, lawyer, credit debt, bankruptcy, legal action, hearing, evidence, and so on. Civil procedure, civil dispute resolution in general. Civil procedural law is the legal discipline that organizes the relationship between the subjects of any civil litigation and determines the rules to be carried out by civil courts in resolution of disputes. Sources of civil procedure, courts, and principles to be followed. Civil procedure law has three sources. One of them, and the main source of the civil procedure law, is Code of Civil Procedure in Turkish law, and Court of Cassation opinions, decisions, and legal literature. But the legal literature is the lowest, has the lowest effect of to be a source of the civil procedure law. According to Article 9 of the Constitution, the judicial power shall be utilized by independent courts in the name of the Turkish nation. There are three levels of courts in civil judiciary. Highest court is named as Court of Cassation. Medium-level courts, circuit courts of appeals, and lowest courts are local courts, or other name, civil courts of first instance. The most important principles in the civil procedure are the procedure in litigation is administered and governed by the judge, not any other one. Right to a fair trial and the right to be duly heard. The hearings in the court are open to everyone. The judicial economy principle. These are the most important principles to be followed in civil procedure law. Time requirements and judicial service, parties, types, and commencement of actions. According to the Code of Civil Procedure, time requirements are either designated by the statute or determined by the judge. Time requirements designated by the statute and definitive are definitive. So, if a time requirement is designated by a statute, so that time requirement is definitive. But if a time requirement is designated by a judge, it's not definitive. All judicial documents related to litigation must be served to the parties by the court. Service is similar to mail or notice, however, it is stricter. So, in civil procedural law, parties of an action, of a litigation, are two. One of them is plaintiff and second is defendant. Plaintiff is the party applying for legal protection or asserting the claim, and defendant, the party against whom a remedy is sought or asserting a defense. So there are kinds of actions here. Let's have a look at this. Actions for performance, in Turkish eda davaları, declaratory actions, in Turkish tespit davaları, and constructive actions, in Turkish inşai davalar. So how about preliminary examination and trial? Preliminary examination must be carried out upon the conclusion of the exchange of pleadings. The judge checks the procedural conditions of the action and decides whether it's suitable to go to further judgment on the merits. Examination on the merits is carried out at the trial stage, withholding hearings. Hearings are highly formal in civil procedure and must be carried out according to the statute. The parties have the right to prove, in accordance with time limitations and procedures stipulated by the statute, matters that must be proved with certain types of evidence according to the statute may not be proved with other types of evidence. Here are two kinds of decisions of the court. Interlocutory decisions made in order to resume the action as opposed to terminating it are not appealable in principle. And final decisions mean that judge is no longer examining the case, so the final decisions are appealable. Provisional legal relief and appellate remedies. Provisional legal relief is any kind of temporary relief which may be granted by the court before or during the litigation or the proceedings regarding to the subject matter of the dispute. Since the court of first instance may err, a means of review must be present in order to comply with the right to a fair trial. The two most important appellate remedies in Turkish civil litigation are istinaf and temyiz. Compulsory enforcement law is, in general, comprises of two major parts. While first part of the discipline deals with individual debt recovery and is called individual enforcement, the latter deals with the creditors and assets of a debtor as a whole and is appropriately called collective enforcement. The ordinary procedure for attachment is the principal procedure under the CCEB. The statute provides rules regarding this procedure in detail while making referrals to said rules with regard to the other procedures. In order for the ordinary procedure for attachment to be pursued, either the credit must be monetary or the debtor must be obligate to give a collateral security. So we have come to the end of this chapter. Have a nice weekend.